All right, all right. It might be daytime somewhere in the world where you're at. It might be nighttime or otherwise. But right now, a lot of people are lost out at sea and you're stuck. You're swimming and you're in like a whirlpool constantly. You can't get out. You don't know where you're at, or you're deep down in a rabbit hole and you need to come out. And most of it involves the employment environment. Most of you are going through labor, and labor is not a commodity. And the word employ includes to suffer or be permitted to work for another, right? I got notes on the board. If you see me looking over there, I'm reading, right? Since we all live, we all die. A lot of times we suffer for everyone and we hate it, but in reality, only we can make it out. So it's a duty of everybody. Now, one of the principles of labor and employment is the principal's duty to the agent. Just as agents owe certain fiduciary duties to their principals, so do principals owe ethical duties to their agents, such as compensation and job-related expenses. If an agent incurs expenses or liability while acting on the principal's behalf, for example, it is only fair that the principal should assume responsibility for those expenses or that liability. Principals also owe their agents a duty of cooperation. One might expect most principals to cooperate with their agents out of self-interest, but this is not universally the case. Suppose a principal hires an agent on commission to sell a building and the agent puts considerable time and expenses into the process. If the principal changes his mind and decides to retain the building, he might want to prevent the agent from completing a sale. Is such action ethical? Does it violate the principal's duty of sale? Does it violate the principal's duty of cooperation? What alternatives would the principal have? So even when you look through stuff, they'll say that what people don't get is the principal technically doesn't really owe a fiduciary duty to the employee or otherwise. They say that after all, they maintain, why should an employee be loyal to an employer's interest over the years when the employee knows that the employer has no corresponding legal duty to be loyal to an employee's interest? Employers who do show sense of loyalty to employees, for example, by not laying off long-time faithful employees when business is slow, or when these employees could be replaced by younger workers at lower cost, base the sense of loyalty primarily on ethical, not legal consideration. So in a legal consideration, the employer has no obligation to the employee. Most states have a right to work clause. This is really big. That's why they have that term. The word employ includes to suffer or be permitted to work for another. And labor is not a commodity. And labor and employment are two different things. So let's get right into it. Even this book that I'm reading from is called Sixth Edition West Legal Environment of Business, Texts and Cases, Cross Miller, Ethical, Regulatory, International, and E-commerce Issues. So even with it, after you go through the employment environment on the principal agent relationship, you also see they have the regulatory environment. And under the regulatory environment, selected areas of consumer law regulated by statute, advertising, the Federal Trade Commission Act, 1914, Label and Packing Act, 1966, FTC Mail Order Rule, 1975, Credit Protection, 1968, Product Safety, 1972, Food and Drug, 1938. Now, whether you believe in some of these agencies or not, I'm just giving you the information here too that Everything's labor. When you go to court, someone's laboring. Either that attorney or judge was elected, selected, somehow or another, they're operating under some form of labor. So let's get into it and let's use chat for a reference, regardless if you like chat GBT or not. Most people know by now my chat GBT is 10 times different than others. So that's where let's get right to this because you're going to see how big finance comes into all this as well. So let me get a platform on this and attempt to get this done in about the next 7 minutes for everybody. So chat, I was just reading from the 6th edition of West Legal Environment of Business Texts and Cases, Cross Miller on ethical, regulatory, and international and e-commerce issues. Now, emphatically, it talks about employment regulations and also regulatory systems. Predominantly for us, it's going to be on employment, labor, and credit. And that labor is not a commodity, and the word employ includes to suffer or be permitted to work. Though a lot of people in America, whether they were born rightfully upon the soil and the land, or whether they were naturalized there too, also have a legal personality in the system and regulated under NCVHS vital statistics. They speak about that all these agencies, including men and women that use their name and date of birth, would emphatically be under the vital records jurisdiction, where it emphatically focuses on vital records and vital statistics in the United States, uses, users, systems, and sources of revenue. So they're basically laboring or employing the uses, and sources of revenue from our anatomy from birth to death. And they emphatically state this on page 7 and 8 of the NCVHS, and they regulate and show all the different governmental bodies that are single and separate units of the state. And the state is a condition. Explain to people how the state is a condition, and that labor and employment has nothing to do with taxation. Taxation has to do with collection, and that's why you would need certification under Treasury Circular 230 to give recommendation, tax advice, or legal advice, or otherwise. Break all this down, fact check me on it, and do the people born upon the land have a rightful act to work where they don't necessarily have to be arbitrarily a breakdown on all these factors, and do the people have a right to work outside of Social Security or any political or legislative construct when it comes down to a private employer, not under federal statutory law, and when the employee emphatically has wage and income transcripts stating they are not a statutory employee, their rights to compensation and not be included in the remuneration or commerce and trade to suffer or be permitted to work. So let's get this over with. It's going to calculate this while we go through. And you guys, this is a serious topic out there. You got all these groups out here talking about jurisdiction or all these things, but in reality, everything's up. When they want your name and date of birth, emphatically, over and over, they're placing you under this jurisdiction, and it's all about revenue. The whole thing's about revenue. So let's continue to go over this. I'm going to double check what came up. And I'm not an enemy of the state, nor trading with the enemy. I'm not against anyone. I'm attempting to give you guys the truth in all of this. Now, isn't it also true that each attorney, agent, or otherwise for the state would be operating under public labor policy laws and credentials, and also that any agent, employee, inferior officer, constitutional officer, or otherwise, they all have to abide by finance. The state has a budget. They have a criminal budget, civil budget, they have a Department of Health budget, they have an educational budget, police department budget. Everything is budgeted. So in that sense, there's always an employee-employer relationship. And if you're not a statutory employee and you're not commissioned, to be commissioned is also major. For the officer to be on post and position, they have to be commissioned. If they're outside of post and position, they violate their commission thereof with legal sufficiency. Appreciate you guys rocking with me. We're gonna get this done in the next couple minutes and really break this down. It's easier for me to talk to it and have it bring everything back. And you're going to see that, even a state attorney or anybody there, they would have to be on employee records, or like for a big corporation, the attorney would have to be on some type of record for a contract. I'm going to also put that in there. Before we create this notice and demand for proof of commission and fiscal authority, add in the American Bar Association, the American Banking Association, and otherwise legal environment of business relationships to emphatically state that if an attorney acts to having privilege and relationship with their client, they would have to have a rating there too, and it would be on custodial records for that business organization. Otherwise, it may be piracy, bottomry, booty, prize, or otherwise some scheme where they're acting as a layman witness, prosecutor, or private attorney. Cite the laws and codes and parameters there too, especially that would violate labor laws, public or private, if any. So now these things are major topics that I'm talking about. In any case, especially criminal, legal sufficient evidence is a key. It means competent evidence, which, if accepted as true, would establish every element of an offense charged and the defendant's commission thereof, meaning the defendant was commissioned thereof in a statutory act. Most of you don't even knowingly, intentionally, willingly, or even wantfully act upon the statutory regulation, but they presume it upon you because the ignorance of the law, you don't know how to object that. And in a commercial world where they're budgeting for politics, they're in some form of commercial nature. That means they're competing against your interest. Let's reset this. Make sure I get the right information. We wanted to create this for us. All right, so let's go to the top and go over this, and then I'm out for the night. So the state is a condition. That's what people don't get. Now, the republic for which it stands or the state of where you're at is different than the state of a condition. So when they say state of Arizona, that's a condition. Or they say state of California, that's a condition. Condition of the Federal Republic and the Federal Union. A lot of you need to see that too. Explain also why state of Arizona, state of California, state of New York, these are conditions. These are not the republic for which it stands. They're a condition thereof. And they have all the right in the world to act therefore. But so do the people have the right to consent to be governed by another under whatever form of law and construct thereto. Cite the overwhelming judicial rulings unanimously that the sovereignty is not necessarily amongst the several states of the Union or the federal compact that supersedes most state existence, but the sovereignty still remains amongst the people, and that there's always a top-down principal agent or otherwise structure, and that everyone is being employed in some form or faction under statutory terms and conditions of law. Man, you gotta look over this stuff. So let's go through it. The state is a condition, legally and juridical meaning. In Constitution and international law, the state is merely a place or building. It is a legal condition created by the consent of the governed and maintained by jurisdictional acts. The state exists as a body politic or juridical fiction that administers the laws, contracts, and obligations of its members. See United States versus Crankshank or Cruikshank, whatever it is, 92 U.S. 542, 1875. Texas versus White, 74 U.S. 700, 1869. As a condition, it represents an ongoing relationship between men and the administrative agencies empowered to govern property, labor, and commerce. A person may be within a state physically, but not of the state juridically. This is the distinction between state status and domicile. Pay attention. Thus, when NCVHS and Vital Records speak of vital statistic systems, they refer to the state's administrative condition, a data framework for identifying, recording, and monopolizing population events, birth, death, marriage, as instruments of governance and finance. It's a term of art. The word person in law is a term of art. Look it up. Labor versus employment. Labor is not a commodity. The phrase originates from the Declaration of Philadelphia, International Labor Organization, 1944, and was later embedded into the United States public policy through Fair Labor Standards, FLSA 29 USC 202A. That's the regulatory body. Most of you out here are involved in labor that involves remuneration and sometimes makes it a commodity. It's not supposed to be a commodity. Human labor, right, cannot lawfully be bought, sold, or treated as merchandise. Employment, by contrast, is a contractual relationship under statutory or commercial law involving remuneration for services rendered. So employment and labor are two different things. Thus, labor exists as a natural right. Employment exists as a regulated privilege. So if someone doesn't have regulated power, how could they regulate employment upon you and deny your natural right? Right? So let's put that in here. So if someone does not have privilege and rating for a statutory regulated privilege that involves employment or recommending certain employment voluntary actions like a W-4 or otherwise, and then deny someone's natural right that exists under labor, that would be a non-derogatory right that you couldn't ever eliminate, your labor. So if they don't have regulated privilege, they can't commingle or interfere is the objective. Find all the newest case laws based on that and the etymology and oldest case laws as well. Only ones that are still usable. All right, let's keep going. You know, I'm spitting game tonight. I used to tell the judges, this is all about labor and employment. You're not going to get away from it. Ain't nobody getting away from it. There's no statute of limitations on a fraudulent tax return. And if they're violating you in labor and employment, that's something to look at. And it's going to be governed under the state budgeting and finance. Right from New York's governor and New York State Budget Summary 1960, and I can tell you this is still a due clause today, right? I'll even read this in here. Explain to the people that not missing here is the budget was developed in the best interest of our citizens, school children, as well as taxpayers, the old and the young, farmers and city dwellers, business and labor. It is our responsibility on behalf of the people of the state to ensure that their state government serves their needs, efficiency, and well, and with a minimum tax burden upon them. Government, if it fulfills this aspiration of our people, becomes a tremendous force of good, encouraging economic growth, permitting high standards of living, and encouraging the fullest possible development of each individual. That's from Governor Nelson A. Rockefeller, budget message, February 1st, 1960. And I believe this would be emphatically the truth in all states across the board, that there's a budget for criminals, civil, for everything out there. And it places them in a fiduciary duty to abide by that budget. And when there's an attorney, or there's an officer or otherwise outside of their delegated duty and not appointed by special duty there too, they don't have liability, they don't have immunity. They're now liable to the fitness, performance, and attributes of the account of a private citizen or otherwise. These are undisputed terms and conditions. All right, let's get back to the scheduled program. It's all about labor, right? So again, employment and taxation are not the same thing. A lot of people don't get it. And your job is certified by you getting hired. The employment aspect for taxation is a collection method afterwards, right? So tax law regulates the collection of revenue from transactions, profits, or taxable activities. Title 26, that'd be a regulation. Whoever's speaking on that would have to have privilege and ratings there too to give you a recommendation. More than likely under Treasury Circular 230, I can't give you legal advice or tax advice. I can only tell you what I know from being a prior repairman and having privilege and rating under Title 14. I believe it's the same across the board. They're lying and cheating you. If they don't have a privilege and rating, they don't have a delegation of authority, and they might be injuring you with the unfair and partial hearing when the law and the interest of justice is for fair and impartial hearings. So only those engaged in trade and business as defined in 26 USC 7701A26, that is performing the functions of a public office or federal employment, are automatically employees for purposes of federal income tax. But a lot of you are out there are forced into this by your HR. And HR might be the cruelest, meanest people out there. I'm not against anybody either. You guys got to understand, I get an average of, like this last month, it says over 700,000 people on all platforms that reach out to me. So if I don't get your message, sometimes you might message me, you got to message me again, or it might pop up, days later after I message stuff. This is a tough job, right? So let's keep going. These people are regulated. I'm not regulated. I'm not holding public office or acting as a federal employee. I'm in a private membership association, and I encourage people to join my private membership every Saturday evening. And I give you access to lifetime, all my information. And I don't charge you over and over again. It's a one-time donation. That's all. Hence, a natural person working for a private, non-federal employer may not be a statutory employee, and their labor for hire can be considered private compensation rather than taxable wages if properly documented. That's the thing. I help people properly document this to overcome. And I got people that work all over the world and I help them out with this. Let's keep going. So I'm going to drop this link for everybody to read on my Instagram page and my YouTube page. And let's keep going through it, right? The FSLA itself determines employ broadly as to suffer or be permitted to work. 29 USC 203G, meaning any allowance of labor. But this definition is only binding upon employers subject to the act, interstate commerce, enterprise coverage. And I'm telling you, when they say there's a pipeline from school to prison, they're employing you. And when the judge has plenary power and it's not by the Constitution, he says he's all powerful in that court. It's only to a certain point of competence. And when you say you understand, that means you're operating in your commission. You agree to be commissioned when you understand. It's like my honor and district attorney or opposing party. I may have read the bill of particulars. I may have read the indictment, information, charges, complaint, billing statement, or otherwise, but I do not understand it unless it's produced with a custodial of records under full faith and credit, notary power, or declaration with or without the United States emphatically, where that employee holds a delegation of authority of custodial records or otherwise equivalent and affirms on and for the record or declares on and for the record that emphatically they have seen and have recognized and can interpret either I've placed them in the red or I've placed them in the black by a fiscal day, week, month, or year from a fiscal injury, in fact, bodily, mentally, medically, financially, legally, or spiritually, and without a claim for which relief can be granted by a claimant that has that evidence, they fail to produce evidence, and therefore I shall not be employed, I shall not be labored for any degree of civil, criminal, or otherwise to suffer or be permitted to work for another that fails to produce a claim for which relief can be granted or fails to produce post and position to even regulate the so-called law that they're attempting to enforce, charge, indicate, or otherwise. And unless you have privilege and rating, how could you even interpret anything under any of these titles of law or otherwise? I yield for the opposing party to produce the evidence or cease and desist and govern yourself wisely. So let's keep going. Wage and transcripts, non-statutory employee status. You are not a statutory employee. Under 26 USC 3121D, they define a statutory employee. Therefore, your labor does not automatically fall under Social Security, FICA, FUTA, SUTA. That doesn't mean you don't have an entitlement. You do have an entitlement. People say, prove it. Right from Social Security's own document, you tear your Social Security card off right next to this. You should contact us to update your Social Security number and the benefit record if you are entitled. It doesn't talk about benefits or privileges. If your name, your U.S. citizen status, or your status as an alien in the U.S. changes, you will need to file an application for a replacement Social Security card and provide proof of your identity, and we may request other evidence supporting the change. Hey, I'm no longer identifying as a creature, as a thing, as a freak, as a monster, as a vital records under NCVHS that places me under the vital records jurisdiction if I use and identify such as it states. And emphatically, all these other agencies are under the jurisdiction there too. In such cases, remuneration may be classed as private compensation for private services subject to voluntary assessment. That's your voluntary assessment, not compulsory taxation unless one knowingly operates in commerce as a statutory person. Man, I reign supreme at this. There's been nobody on the planet to do what I've done over the period of time. This is just a fact. Get over it. It's not about me. It's about all of you because you've all came to me to say, Joshua, do what you do best. Don't give legal advice or tax advice. Give us the proof. Say it, do it, prove it. Go out there and act on it. And since I came out since day one, I show and prove daily. Let's keep going. So I'm going to drop this in there for everybody. Public agents and the state's labor policy. Every attorney, agent, employee, or officer of the state is governed by public labor policy and fiscal law. I've been saying it. Under 5 USC 2101-2105, a federal employee is defined as a person appointed in the civil service of the United States whose compensation comes from public funds. Get in where you fit in. Similar, state officers and local employees operate under state budgetary appropriations, which means every act they perform is funded labor under the authority of their state office. You know, I figured out today, shout out to Acasio and the group again, and New York law, because we were doing studies today. And emphatically, this is major. In New York, they talk about an attorney that fills in a role for the general attorney and fails to produce that he's the special district attorney. The court may not necessarily push him out. You guys know that. But what people don't understand is you can have a major labor and finance claim by going to your state's Department of Finance, your state's Department of Budget, your state's Department of Labor. Go to the Attorney General, go to the court, tell them the emphatic problem is you're not getting a fair and impartial hearing. Therefore, it's a manifest of injustice. The case needs to cease and desist until they can find someone, somebody, or something that can act appropriately through the budget, be appointed appropriately, and not deny the interest of justice. Justice is blind. So therefore, the information needs to be emphatically complete. And when they say blind, meaning they're not looking at either side, they're looking at the letter of the law. They're blind outside the letter of the law. In effect, their work is public employment governed by statutory mandates, collective bargaining agreements, and fiscal limits of the state's appropriated budget. So yes, every one of them labors under public policy and public finance. They cannot step outside these constraints and still claim lawful authority. Oh, you're going to learn tonight. You're going to learn tonight, man. So that way you're not back there out lost at sea in the water, drifting in the waves. So I would really go through this. You know, I don't want to make this an hour-long call, but I would really, you know, I'm going to drop this so you guys can read it. Norton versus Shelby. An officer de facto who holds office without lawful title is usurper, and his acts are void. Usurping comes with use. Remember, this is all about use. You're being used out here, and they're talking about money. Everybody's telling you to go to the Treasury or Social Security for some goofy secret trust fund. When they talk about follow the yellow brick road, they're telling you the truth. It's all about the registrar. And the deputy registrar, the deputy clerk, they rock a green jacket and they hold the biggest purse on the planet. Oh, yeah, it's big money. Solid black and green lines denote typically processes and payments respectively. Dashed black and green lines denote other less common processes and payments respectively. And it's all about birth and death. Death data to terminate the payment of benefits, and private organizations which use death data to pay benefits and prevent fraud. So don't tell me there ain't private organizations in it. They tell you it right by their own words and terms. We're almost done. So legally, sufficiency, and fiduciary duty. When an agent acts under state power, they owe fiduciary duty to the public trust. Their compensation arises from public credit and taxation. Their authority extends only to the limits of their commission. They have to be commissioned and the scope of their appropriated budget. My honor, are you under the limits of your appropriate commission and the scope of your appropriated budget? Or are you outside of that, considered the same as a private citizen, and you owe a tax there too? And I believe that their form of labor includes employment, where our form of labor does not include employment, meaning we don't include to suffer or be permitted to work for others, but they forced us into this. Mostly human resources is your biggest enemy. I'm not an enemy of the state nor trading with the enemy, but I have reason to believe and do so believe your biggest battle is going to be human resources. They will have zero delegation of authority, zero experience, zero interpretation power, zero privilege and rating, and therefore they'll be acting outside of the construct of duty, practicing law when they don't even have a regulation to do so. And remember, I'm not practicing anything tonight. I'm narrating what's out there, what I would do, and if I was the people, what I would look over. And if I was the government and a regulator, I would be kicking ass and taking names. You think Doge or somebody's doing an audit? This shit is most of this shit is a joke. If the governments of the world or anybody in the world, you want a real audit, I challenge the world. Nobody can do the type of audit I'm going to do. Either they put you in the red, they put you in the black. There's a fiscal day, week, month, and year, and there's fitness, performance, and attributes of the account. They were either delegated, regulated, or they were in a despot position, operating outside of their authority, and maybe outside of the constructs of law, causing you unfair partiality to your life. And that's outside of the government regulations. That means the government is not wrong. That means people everywhere are wrong, whether it's in the government or whether it's on the street. We got to meet and confer by the golden rule and come to a decision together to change the world. That's what we're here for. All right, let's keep going. Then their actions are legally insufficient and voidable ab initio from the beginning. See United States versus Lee, 1882. Even the sovereign may not act without lawful authority, meaning I can't come in there and tell you what to do unless I'm regulated under some form or fashion of the law and I have some type of power to do so and some type of rating. When I worked under Title 14, I had ratings and privileges. 12 to 13 out of 25, that's the only thing I could act on. They're going to have the same thing under every title, banking. Any title you go to, they're going to have ratings and privileges. If they're outside of that, they lack any form of what do they call it? Any kind of protection of the law, basically. They can't say they have any immunity. They lack immunity. Now they have full liability, period. So, this is a good breakdown of all this stuff tonight. Attorneys as licensed laborers under public authority again. I broke that down for you guys above. You got to really read over this. I could go all night speaking. The practice of law is a privilege conferred by the state, not a natural right. Therefore, all attorneys operate as public officers within the state labor and licensing system, subject to statutory control and budgetary oversight. That's why you say, here's the W-9, fill it out. You're operating under state and licensing systems with labor and employment, and I have a right to know who you're laboring for and what objects and constructs and conflicts of interest may be arising against me. If an attorney claims privilege and representation, that privilege derives solely from the fiduciary trust relationship governed by model rules of professional conduct 1.6 to 1.8. Look it up. Confidentiality, conflicts, and client property. It does not exist outside of lawful commission or license on file. It don't matter if they're working for ICE or if they're working for anyone, anybody, or anything. Everybody's under a construct of law, even the attorneys on a journey. Most of them are out there at sea, operating under piracy, prize, booty, bottomry, or otherwise. Look up those terms and conditions. A lawyer shall hold property of clients or third persons that is in lawyer's possession in connection with the representation separate from the lawyer's own property. Complete records of such account funds shall be kept and preserved for a period specified by law. That's where you usually get an escrow account. Every attorney who receives funds, retainers, or settlements must maintain custodial records for those transactions. Failure to maintain such accounting constitutes commingling or conversion, which the fiduciary violations under restatement third of agency 801, 803. Look it up. I'm always telling you, restatement of law is the secondary source of law. So this is going to be major when you go through it and read what it could do for you or could not do for you. I can't give you legal advice or tax advice. I know if it was me, I'd create a notice of demand for proof of commission, custodial record, and fiscal authority. And I would go out there and double check all these laws, and I would have faith. A lot of you guys out there dealing with somebody that's never in their life done an international audit, state audit, federal audit, any kind of audit out there. How could they know to tell you what to use and what not to use in your favor? Most of these people out here are capping. Facts. Most of them are capping. They're stealing your money. They have no idea about these things that I'm speaking of, and you guys get in all kinds of trouble out there. And then most of you guys are out there talking shit about the government. The government's not wrong. It's the people. I'm not talking about like us. I'm talking about as a whole. People have to come together. Meet and greet is the golden rule. So again, all of this, let's double check what else we got in here. Appreciate everybody greatly. Let me get some of this water. All right. So like I said, I'm going to put this link in the chat for everybody. You really want to go through the whole thing, especially on the sections of American banking. Bottomry refers to pledging a vessel or goods as a security for a loan at sea. Prize of booty refers to unlawful taking under false authority. All these things cause the deprivation of rights under the color of law. Most people out here that even do this don't even know they're doing it. Most of you guys out here are paying taxes under state laboring licensing and all kinds of other actions. Again, you'd have to look it up. I can't give legal advice or tax advice. So effectively, a layman witness, private prosecutor, or uncommissioned agent operating outside the lawful employment relationship, such acts violate 28 U.S.C. 219 FLSA compliance for laborers and UCC 1-203. And as well, I would say 1-304, good faith. But this is for good faith and fair dealings. Again, I would go through all of this stuff as much as you could. Remember, state is a condition, it's not the republic. Go through that stuff. The state itself is but the organized community. The people are the sovereign of the country. Look these cases up. This is a fact. There's no way around this. Most of these places are in a federal compact when you look it up. So people, federal constitution, states, counties, municipalities, officers, employees. Again, I appreciate everybody greatly. I would go through all this stuff with an open mind. Don't go out there in the world and make anybody else suffer, be permitted to work for you. Take advantage of all this information I give you out there. Don't go out there and abuse your employer. Don't abuse your employee. Don't abuse your fellow man, period. The law of Joshua is upon you. That's not just me, man. That's not me. That's a scripture if you look it up. The law of Yah is coming. That's salvation. Has nothing to do with me. has to do with we, everyone. So again, they're going to have a lot of big cases here that you could look through. Public employees cannot be compelled to subsidize union speech underscores that employment does not erase constitutional rights. Here, speech association useful where membership fee is demanded as a condition to work. Right? All these things are big. And again, I give you guys links where you can go look them up. So take advantage of all this stuff. How to argue your specific no privilege, no rating, no commingling point. Demand the source of authority. Require custodial financial records. Apply right to earn a living precedent. If there's no evidence, the judge has no precedence. If there's no evidence, how could you render to have to suffer or be permitted to work for somebody else if there's no evidence you're under public policy? That'd be a violation of international labor organization as well as state and federal labor organizations anywhere. So again, these are big things to look up. I put a lot of big topics in there because a lot of people out here are suffering for labor or work because no public funds may be spent outside of legislation appropriation, any act claiming to incur liability or obligation for which no appropriation exists is ultra vires, meaning under Regulation U, if they buy your instrument and then someone else is the customer, maybe the bank or such of the Federal Reserve to get the federal credit, they pay the dealer the cash for the finance charge, and then the amount of credit provided to you or on your behalf is not just numbers on a screen. They're actually Federal Reserve notes. They call it Federal Reserve credit, eligible paper, commercial paper. The amount of credit provided to you or on your behalf is to hold up the national banking structure. They need that credit on their books to earn the interest. It's a discretionary trust. It's an SMA account. I know this because I have these. I'm not out there under voyeurism. I'm not out there under vanity. I could go buck wild crazy with the amount of credit or funds. And really, one of the main things that stops me is helping people or bitching and complaining about maybe my friends, my family, my son, or others, because yeah, sometimes I want to go out there and live it up and turn it up. But you know what? I know that isn't always the best thing. For me, if I had all the freedom in the world, it probably wouldn't be the best thing. I'd probably be with 20 women right now, so I'd be in trouble. I need to be in here. So until I learn that lesson, I'm emphatically in this process. Regardless of how much money, funds, and credit I have, I got enough stability and mental construct to say, you know what? I got in trouble out there, so I'm gonna stay in here. I'm not lost out at sea no more. You might see me halfway above the water, but in reality, this is just imagery. I'm back in the game. So let's keep going, man. We got to finish this out. All this is important. You need to look over this. It's not about me. It's about you guys changing your life. All right, so we're going to do final. Let's reset this to make sure we got everything up to par. Then I got to get out of here and make this video less than an hour. All right, let's get to it. Declaration and questionnaire of labor status and equal protection. I, one man or woman standing in my proper person and capacity, make this declaration pursuant to 28 USC 1746. I would say emphatically without the United States and within the United States of America upon the republic for which it stands, affirming the following questions and statements to clarify my status or lawful labor status and to prevent discrimination, coercion, or misclassification in any civil, criminal, or administrative proceeding. I assert my natural and constitutional right to labor, to contract, or not to contract, and to be free from involuntary servitude or compelled statutory association. Are you alleging or presuming that I'm a statutory employee defined under 26 USC 3121D or 29 USC 203E, not limited thereto? If so, please produce the executive contract delegation establishing that status. And I would say if it's a W-4 or otherwise, I have the right to emphatically revoke, rescind, and terminate that relationship thereto by corrective action. When I used to work under Title 14, if somebody made a violation, the feds would come in and say, you got to do a corrective action within the next 30 to 90 days. If you don't do it, that's when you would be fined like $10,000 or possibly taken to court for not correcting the action. So if you made an action out there that was not correct to your status, entitlement, or otherwise, correct the action. And if I'm talking too quick for you or above the level, play it back as many times as you can until you can comprehend this. Now let's keep going. Do you acknowledge that labor is not a commodity under the Fair Labor Standards Act and Declaration of Philadelphia? Are you aware that my right to labor privately for livelihood is protected under Yick-Wohl-Hopkins, also Truax versus Ratch, and Butchers Union versus Crescent City? I would say not limited there too. And now and for then, are you claiming any jurisdictional, fiscal, or contractual interest over my private labor or property? If yes, state the statute and delegation authorizing it. Do you possess any lawful commission, oath, or appropriation authorizing you to make determinations regarding my labor, employment, or compensation? Again, it's going to be really tough for them. This is one of the biggest ones. Do you acknowledge that discrimination in public or private employment on the basis of religion, national origin, belief, or political status is prohibited under Title 42 USC 2000 E2A 1983? All right, you guys, I'm out. I appreciate everybody beyond imagination. We're gonna do a follow up. We'll do a follow up. I'm gonna drop this, and I appreciate everybody out there. Make sure you guys don't take advantage of this in any negative way. This isn't for sale, retail, or otherwise. It's not for commerce and trade. It's to help people out. The link, copy it. All right, man. I'm out. Appreciate y'all, man. Stay and keep yourself fit. You know, I might be in these baggy clothes, but believe it, behind the scenes, man, I'm getting real strong right now. And you know, they always talk about uh stay lean and mean, have a fighter's body or have a bedroom body. You know, back in the day, one of the OGs used to always say the key to life is keep a bedroom body or keep a fighter's body. And that's really, man, keep fit, man. Keep fit, keep the heart fit. There's all kinds of different things out there, whether it's your lymphatic system or whatever. A lot of you guys out there, get up, move around, do some push-ups, do some squats, do some kicks, do something to get yourself in the game. I'm out.